Well, good afternoon, ladies and gentlemen. Welcome to the rooms of the Bar Association of Queensland. It's a great honour to host this seminar tonight. For those who don't know, my name's Damien O'Brien. I'm the President of the Queensland Bar Association, and we are very honoured indeed to be hosting tonight the 2023 James Merrills Fellowship in Law Lecture presented by the Honourable Justice Stephen Kós of the New Zealand Supreme Court, formerly of the New Zealand Court of Appeal. We also have in attendance tonight Professor Matthew Harding, the Dean of the Melbourne University Law School, and Professor Harding will introduce the good judge in more detail. But I will introduce Professor Harding. As I mentioned, he's the Dean of the Melbourne University Law School. He is a well-known academic. He's published extensively on topics in the theory and doctrines of equity, especially fiduciary law, charity and not-for-profit law and regulation, the law of property, judicial practice and precedent, and the philosophy of trust, amongst many other topics. Professor Harding teaches a range of subjects at the Melbourne University Law School, both in private law, legal theory and charity law. He has been a visiting scholar at the University of Toronto, Queen's University Belfast, the University of Otago, the University of the Western Cape, and in 2020 he was also a distinguished visitor at the National University of Singapore. Could I ask you to welcome Professor Harding?
Well, thanks very much, Damien. That was a very generous welcome. And thanks to you and the Bar Association for hosting this event this evening. It's great to be here, and it's great to see so many people in attendance. I'd like to say a few words, if I may, about the James Merrills Visiting Fellowship in Law before I introduce our distinguished speaker. The James Merrills Visiting Fellowship in Law was established in honour of James Merralls AM KC, who was an alumnus of the Melbourne Law School. He graduated from our law school in 1958. In the early part of his career in the law, he was a resident tutor in law at Trinity College at the University of Melbourne. That was for some years between 1958 and 1972, and he was Dean of that college in 1967 and 68. He was, of course, a leading silk working at the Melbourne Bar with an extensive practice in constitutional law, but not only in that field, also in private law as well. But perhaps his best known contribution to the profession and to our legal system was in his legendary role as the long-standing editor of the Commonwealth Law Reports. His work as editor of that series was commended and celebrated over many years by leading practitioners and judges, including Chief Justices of the High Court of Australia. Each year at the Melbourne Law School, we select a leading jurist from around the world to visit as a James Merrills Fellow. The James Merrills Fellow is involved in the academic life of our law school, and one of the duties of the Fellow is to teach to our students, and Stephen Kós has in fact been teaching this week with me and with Joseph Santamaria KC, and also is expected to deliver a public lecture on a topic of interest to practitioners and academics in law. The lecture is to be delivered once in Melbourne and then again in another Australian capital city. And when Justice Kós was asked which other Australian capital city he would like to deliver the Merrills lecture in, he came back adamantly and immediately and told us that Brisbane was the only city that we should consider. and so that's why we're here. Can I acknowledge in this forum the generosity of the many friends of James Merrills whose support has made this fellowship possible. And many of those individuals were in attendance on Tuesday when the lecture was held in Melbourne, and there may be individuals here this evening who have supported this initiative, and for that, thank you. Can I then turn to our speaker this evening, the Honourable Justice Stephen Kós of the Supreme Court of New Zealand. Justice Kós was the son of a Hungarian refugee born in a town called Mosgiel, a town I know well. It's where my wife comes from. I can tell you it's a rather remote town on the South Island of New Zealand. Then raised in the North Island in Wainuiomata. He arrived at Victoria University of Wellington at the age of 17, where he matriculated in 1976, studied law, graduating with an LLB with honours in 1981. His LLM was from the University of Cambridge. It was earned in 1985. Then on his return to New Zealand, Justice Kós commenced a career in commercial litigation, a partner at Perry, Wiley and Page, and then at Russell McVeigh. He then went to the independent bar and was appointed a Queen's Counsel in 2007. With three other silks, he founded Stout Street Chambers in 2007. In 2011, he was appointed to the High Court of New Zealand and then to the Court of Appeal in September of 2015. He became president of that court in 2016, where he was an active leader, reforming rules and process, encouraging junior counsel to address the court, creating reforms to the timing of sessions, and so on and so forth. After some years of service as president in that court, he was appointed last year to the Supreme Court of New Zealand. Much more could be said. I won't say it because you're not here to listen to me. But one of Justice Kós's abiding interests is in legal history, and it's that theme that he picks up this evening in his lecture. And so I will invite now Justice Kós to come up to the lectern and talk to us about citation practices across the Tasman. Thanks, Justice Kós.
Well, tēnā koutou katoa. Thank you, Damien, for your introduction, and Matthew for your kind remarks. I found it's always a good idea to be introduced by a friend. I applied that practice when I was sworn as a judge a dozen years ago. 3 friends of mine were the speakers on that occasion, and it's only fair to say that the progress of time has simply dashed great expectations. I want to thank both the Melbourne Law School and the trustees of the James Merrills Visiting Fellowship for inviting me to take up the fellowship this year. One of the particular pleasures of it has been the teaching aspect as well as the lecturing side. But as Matthew mentioned, he and Joseph Santamaria and I have spent 3 hours, a class that just seemed to fly by, on Monday, and I return on Sunday to Melbourne for the second class, which is on Monday, which is apparently Labour Day, but Melbourne Law School doesn't recognise Labour Day, and the students are required to attend. Respects also need to be paid to the memory of James Merrills, in whose name this lecture is held. I've read much about the personality of Mr. Merrills, a great deal more than simply appears from the bare statement, General Editor J.D. Merrills KC. Like many young barristers of a different age, he dabbled in journalism. He dabbled quite a lot. He was in fact a professional journalist, theatre critic for The Nation magazine. A trenchant critic, one of his reviews described the production as Mozart without the music. On one famous occasion, the editor was required to give an enraged director a righted reply which ran to a full page. He was also a very famous horse breeder, and that was a quixotic choice, even though he was the Tasmanian Racehorse Breeder of the Year and the Australian correspondent for the British Racehorse, a journal which I confess I had no prior knowledge of. But despite this interest in racecourse breeding, he was in fact physically allergic to horses. His widow told me the other day that he used to say, "Stand away from them, they're dangerous." But the real reason is they made him sneeze. Well, this fellowship celebrates Jim Merrills, the lawyer, celebrated constitutional lawyer, counts on many of the great constitutional cases of the 60s and 70s, although he then quite understandably swerved in preference for cases in equity. And of course he was celebrated editor of the Commonwealth Law Reports for 47 years. As quite a lot of what I have to say tonight is about law reporting, it is, I hope, a lecture that he would have enjoyed, and I hope it's one that you do. Now, in 2001, Sir Ivor Richardson, who long preceded me as President of the Court of Appeal in New Zealand, stood back and he looked at case citations from other jurisdictions in his court. He looked at the years 1960, 1980, 1990 and 2000. And as I've recently done, he got his clerks, you call them associates, to help him. Looking at citation in New Zealand of Australian cases, a bell curve was apparent. A rise from 4% in 1960 to 12% of case citations in 1990, but then a plunge back to 5% in the year 2000. And so Ivor mused over why that might be. He said that a partial explanation is the difficulty of dealing succinctly with decisions of the High Court of Australia. Many contain, there are no High Court of Australia judges. She Damien, now grab a glass of water.
Yes, sir.
In case I need to protect myself from. He said many contain multiple judgments with different judges often taking somewhat different approaches, thank you, to a single legal issue. Well, in its own terms, that explanation is a curious one. Had the High Court's methodology changed so much in a decade? In my last year as President of the Court of Appeal, my senior clerk, Dinah Chu, and I were musing over what remained a pronounced lack of Australian citation in New Zealand cases. We decided to revisit the subject and to resolve, if we could, 3 questions. What are the New Zealand citation trends of Australian cases? What about the Australian trends for citation of New Zealand cases? And what legal and social considerations explain the trends? Now, one of those 3 questions is harder than the others, but they are the core of what I want to talk to you about tonight. So here's briefly what I'm going to do, a little bit about background, a tiny bit about methodology, then we'll go straight to the findings. Rowing in reverse is about your citation of us, as opposed to our citation of you. And then I'll try and offer some explanations and engage in a little feeble punditry at the end. So, prior studies. There are 2 prior studies. One of them is Sir Ivor's one, which I've just mentioned. The other was by Dr. Russell Smith of Monash University, and that was a snapshot of citations in the New Zealand Court of Appeal over 4 years, from 1995 to 1999. And we can summarise its results. Here comes a table, but I'm going to take you straight past the table to a graph in a moment, so the table takes quite a lot of absorption. But the graph. Oops, hey. Oh, apparently I'm not going to take you to a graph. I didn't do a graph for this one. All right, I shall now describe what you're seeing. You see, this is the great thing about New Zealand, is we cope with technological problems. We cope with technological problems of our own making. What you'll see there is that the New Zealand Court of Appeal cited New Zealand cases a lot, especially its own previous decisions. So the top right-hand figure, 36% of citations in the New Zealand Court of Appeal, and the Smith study were NZCA decisions. And just over 50% were New Zealand decisions. Secondly, decisions of the English and Welsh courts made up a quarter of the citations in this period, 95 to 99. And thirdly, decisions of courts other than New Zealand and England and Wales accounted for about 20%. And of that 20%, here's the important statistic, 9% were Australian in that period. But that was a snapshot. It's not good statistics. It's a snapshot of one court in just 4 years, so more was needed. So Ivor's study was more than that. He looked at 4 different years, but they were spread apart. And notably it showed, amongst other things, you'll see, if you look at the total at the bottom, a very substantial increase in the workload of the Court of Appeal during that period, which is not matched by the increase in the number of judges serving on it. But the citation trends in there are what we're here to talk about tonight, and I'll show you a graph of that. And you'll see that the black line there is of New Zealand citations. Blue is England, is the United Kingdom. Yellow is Australia, a rather flat sort of bell curve. And what do we see there? Well, the first really interesting thing, I think, is the proportion of English or United Kingdom citations plunges. From 69%, they plunged by the year 2000 down to just 17%. Correspondingly, there's an absolutely commensurate rise in New Zealand self-citation. So New Zealand cases, whether they are cases of the Court of Appeal or of the High Court, displace the English authorities. Australia, well, you'll see there that what happened was that it rose from 4% in 1960 up to about 12% in 1990, and it fell back again to 5% in the year 2000. But again, the problem with this is that it's a single year. It's 4 lots of single years. So strange things can happen in a particular year. They may not be representative of a period. So again, not good statistics. So we decided we would engage in a study which avoided the exceptionalism of snapshots and look at a long run and full decades. And so that's what Diana and I did. And there's Diana. I need to put her photograph up and praise her endlessly in front of you, because the heavy lifting was done by her, and the heavy lifting that was done was literally heavy lifting. She walked around with these gigantic A3 photocopies of the tables of cases cited across 4 decades, and all of them, each of them individually coloured according to source. Over 61,000 citations were analysed. So she did the quantitative analysis and I did the qualitative. That does not necessarily mean that the qualitative analysis is of a higher quality than the quantitative analysis, because that was certainly very sound. Our methodology was, we looked at the tables of cases cited for the New Zealand law reports, 50s, 70s, 90s and 10s, the whole decade. We separated out Australian, United Kingdom, New Zealand and other cases, so we obtained a percentage of the total citations for each, and we engaged in a limited qualitative analysis of the most cited Australian cases, and I'll talk about that in a moment. I'll explain that shortly. So what do we find? Well, again, I think it's quicker to go to the graph, and you'll see that something has happened there that looks kind of like what happened in the earlier figures we looked at. It's certainly very similar to the Richardson study. So you see the English line plunge, we see the New Zealand line rise. They basically displace each other. But what we do see is that Sir Ivor's study, because of its year-by-year exceptionalism, didn't fully represent the extent of Australian citation. It never exceeded 10%, so in his study in 1 year he got to 12, but in that decade, in fact, it was below 12%. But it started at about 6%, it rose to about 9% in the 1970s and the 1990s, and it fell back to 8%, just a slight fall in the 2010s. So I said we looked at the most cited Australian cases. So these are the ones that receive, the areas of law that received three, in which an Australian case received 3 or more citations in the decade concerned. So you'll see in the 1950s, it's quite spread: criminal law, equity, criminal law, family law, public law, tax and torts. But it's almost a case of saying there's nothing to see here, because when you actually look at those cases, you'll see that the Australian citations are make-weight, additional references that the judges have used to add to English or New Zealand citations. So the 1950s is a very barren period in terms of significance given to Australian cases. 1970s, not so much, because there was a fabulous battle in New Zealand between the Todd family that owned the offshore mining concessions on the west coast of the North Island, and the Commissioner of Inland Revenue. And that explains why there were so many tax cases then, because the Todd family were very keen on a High Court of Australia authority called Cecil Brothers, and that got cited a lot, got overruled by the New Zealand Court of Appeal, and the New Zealand Court of Appeal was then overruled by the Privy Council. So that, I think, explains the interest in tax in that period. In the 1990s, there are some obvious points of connection. In fact, the public law cases in the 1990s are not ones of, I think, of particularly enduring significance. They're cases like, not for us anyway, they haven't continued to be cited, so they're cases like Teo and Pico Wallsend. And I don't think I'm not sure that their authority in Australia has continued actually with a great deal of vigour, but they haven't continued particularly vigorously here. Competition in the 1990s, that's easy. In 1986, we pinched your Trade Practices Act. We cut it up into two parts. We called one part the Commerce Act, and we called the other part the Fair Trading Act. And of course, then we scouted around looking for authority, and Australian authority on the very same statutory wording was immediately attractive. So that's why competition features so much in the 1990s. Interesting though, isn't it, that it falls back in the 2010s. The really strong Australian case law from the 1990s that continues to be cited and has real gravitas are the equity decisions, and they're the ones you'll all know: Hospital Products, United Dominions, Walton Stores, Verwayen, Baumgartner and Amadio. Cases that are just part of your equity DNA and have become part of ours. Come on, Sue. And 2010s, well, something of a fallback there. A lot of interest in civil procedure and a lot in tort, you'll see at the bottom. Now, why was that? Well, as you will, I think, know, New Zealand is a temperate, rain-prone nation. And if you live in a temperate, rain-prone nation, a really good idea is to build houses with gables, roofs. But in the 1980s, we changed our building legislation. Actually, in 1991 we did that. The result was an immediate burst of leaky homes, and we turned misguidedly instead to building Mediterranean-style dwellings built with something called monolithic construction, involving plastered walls, flat or curved roofs, and no eaves at all. The result was a sprouting of mould, of litigation funders, and of lawsuits. And so that is very much explicatory of the 2010s figures. So that's what we found. I'll try and offer some more detailed explanations in a moment, but before we do that, I want to look at rowing in reverse and look at your citations of us and see whether the patterns are similar. Now, we haven't undertaken the same enormous undertaking looking at all your tables of cases cited and all your state Supreme Courts and Commonwealth Law Reports decisions. We simply didn't have the capacity to do that. So we did something else. First of all, we looked at Dr. Smith again, and I think it's probably easier if I just take you to the graph. So this is Dr. Smith's analysis of High Court of Australia citations between 1920 and 1996, and you'll see there, again, really interestingly, that same kind of displacement we saw in New Zealand. The English authorities, the blue line, have a bit of life in the 1940s, and it plunges away down in 1996, completely displaced by a corresponding pattern with Australian self-citation replacing English. And the other, well, it potters along down the bottom at something between about 5 and 8%. Of that 5 to 8%, Dr. Smith said that he calculated that 1% at most were New Zealand cases cited by the High Court of Australia. So they're even less keen on us than we seem to be on you. I'm sorry about that. We then, this is interesting. It's quite interesting just to put the High Court of Australia citations alongside our New Zealand all court citations in the law reports. You just see the same patterns. Same displacement of English authority and substitution by domestic authority. But what we also did was we pulled out the law reports, the tables for the Commonwealth law reports, the New South Wales law reports, the Victoria law reports, and the Queensland law reports, and we, using the digital indices, we put in the letters NZLR, which magic in New Zealand for New Zealand law reports. And so if you see NZLR in the cases cited, then we're probably pretty sure that's a citation of a New Zealand case. So I'm not absolutely sure of that, but if I was a betting man, I think I'd say it probably was. And so when we did that, I'll just go straight to the graph. This is what it shows. So, and these are gross numbers. These are not percentages, obviously. These are the total number of citations. For instance, the New South Wales law reports in the 1990s got up to a heady 250 or so citations. But you'll see what's interesting about that is the rise is replicated in other jurisdictions, Queensland, for instance. And likewise, the Commonwealth law reports, the red line. And the Victorians are a little more phlegmatic, but it's the same pattern, a rise in up to the 1990s, and then variously, the Victorian case, a slight plunge off, but in the case of New South Wales and Queensland, a significant drop back, down again for the 2010s. And so, now we come to some qualitative analysis, and I want to try and say why, or suggest why it is that this modest level of Trans-Tasman citation, this dearth of citation on both sides exists. And so here are some suggestions. The first is that it may be that Trans-Tasman affinities have just been overstated. An Australian Government Department of Foreign Affairs briefing on New Zealand says that we are strong natural allies, Australia and New Zealand are strong natural allies, with a strong Trans-Tasman sense of family. The Anzac spirit is a much beloved trope, but, oh sorry, that's not what the Department of Foreign Affairs said, that's what I'm saying. But it may be that Sir Ivor's observation about the cultural and economic affinities between New Zealand and Australia just overstate things a little bit. It's certainly true that we share a population base. In 2018, about 570,000 New Zealand-born people lived in Australia, although you are trying to make us take some of them back. That figure is about 10 times the number of Kiwis living in Britain. So Australia is far more a place of port of call for New Zealanders travelling than Britain. At the same time, there were just 76,000 Australian-born New Zealand residents in 2018. Former New Zealand Prime Minister Robert Muldoon once quipped acidly that every New Zealander going to Australia raised the average IQ of each nation. Well, I'm prepared to accept that Joe Bjelke-Petersen was an exception. History is important, especially that forged at Gallipoli over a century ago, but the Second World War experience was far less congenial. Premier John Curtin and Prime Minister Peter Fraser cordially disliked each other. They resented each other's different strategic decisions after Japan entered the war. Fraser resented New Zealand being left to fight in the Middle East and Europe, although Churchill had almost got down on his knees to beg him to do that. And Curtin, on the other hand, was, as one of his aides said, sour and reproachful that Australia was now also defending New Zealand, and as mad as a hatter that New Zealand had kept its troops in the Northern Hemisphere. Another Fraser, this time your Malcolm, cordially disliked his New Zealand counterpart Robert Muldoon so much that Alexander Downer records that at the 1982 South Pacific Forum, Malcolm Fraser, at the end of his tether with Muldoon, and finding himself conveniently in a hotel room immediately above Muldoon's, jumped up and down the floor endlessly at 1:30 a.m. to wake Muldoon up just for the sake of it. On the other side of the political fence, Norman Kirk and Gough Whitlam and David Longy and Bob Hawke reportedly disliked each other. So relations between prime ministers have not been particularly good in the 20th century. More good-humouredly, we argue about whether Phar Lap was a New Zealand or an Australian horse, whether Lamington cakes and pavlova desserts are Australian or New Zealand foods, and whether Crowded House is a New Zealand or an Australian band. We New Zealanders sometimes, I don't have one of these, I should point out, sometimes sport T-shirts stating, "I support New Zealand and anyone playing Australia." But that's meant as a joke, and it's likely that Canadians have similar ones referring to the United States. It's just about small country, big country neighbours. When I was studying in Cambridge in the 1980s, a Kiwi in the same college put the relationship between our countries well when he said, if I ever found myself in a fight in a pub in London, I could count on an Aussie to help me out. He was the sort of person who would get into a fight in a pub in London, but he later on became a distinguished professor of law at Cambridge. At the end of the day, there is just this nagging sense that we think differently. Australia is a large nation, more interested in Asia and the Americas than its little sibling to the east. New Zealand is a small nation with one hand lightly holding Britain's apron strings, the other the hands of an array of small South Pacific nations. Australia is New Zealand's second largest trade partner. New Zealand is Australia's eighth. Size and isolation give us the luxury of our own exceptionalism, with different stances on defence, being nuclear free, and on the management of pandemics. One interesting measure of the difference between the two nations is seen in the governments that we've voted into office over the last 100 years. What's interesting about this comparison is although there have been governments of comparable hue in 59 out of the 100 years, in the last 50 years that's been so for only 21 years. And even more interestingly, in the last 20 years, the overlap is just 5 years. The other thing that I think we can see clearly from the statistics, both the ones I put up and the Smith study, which showed the decline of English authority in both nations and the rise of self-citation in both nations, is that we have seen the emergence of two newly self-confident jurisdictions, no longer intellectually dependent on English case law. Australia seemed to reach that point rather earlier than we did in the 1980s. We reached that point in the 1990s. That preemption is hardly surprising, given the two countries' respective constitutional histories. You established your High Court of Australia in 1901. We only got rid of the Privy Council in 2004. I appreciate that your Privy Council appeals from states gradually diminished over the years, but I think ended in 1986. In one recent case that we had in the Supreme Court of Criminal Appeal, the appellant had a choice still as to whether to go to the Privy Council or to go to our court. He chose ours. What is perhaps most interesting is that when in the 1990s and the 2010s New Zealand chose to go it alone, reliant in the same way Australia had become on its own case law, with self-citation now dominating, it felt no need to replace Mother England's case law with some of sister Australia's. In taking that course, I think the parallel and preceding course taken by Australia is likely to have been influential. But nor did we feel the need for it. The reality was that each nation now had enough case law of its own. And of course the development of individual bodies of legislation, seldom overlapping, drove the divergence even more strongly. It wasn't always thus. In the 1990s, judicial creativity in the High Court and in the New Zealand Court of Appeal coincided with the leader of Sir Anthony Mason and Sir Robin Cook. Each plainly admired the other. Sir Anthony called Sir Robin an outstanding lawyer and judge, highly regarded not only in New Zealand but also internationally. That's nice. Sir Robin was, if anything, even more enthusiastic about Sir Anthony, saying, in my personal view, Sir Anthony was the best Chief Justice that the High Court ever had, not excluding Sir Owen. It is fair, I think, to say that the close relationship that those two leaders of their jurisdictions had has not been replicated since then. But let's not get hung up on the big man theory of history. Let's move back to stronger statistical considerations. The anchor of experience. Common law and equitable origins in the United Kingdom tend to make its case law a first port of call if our domestic case law comes up short. Connectedly, the great English texts, De Smith, Wade and Forsyth in the public law field, Chitty on contracts, Gatley on libel, Lewin on trusts, boasted on agency, which occupy near monopoly or duopoly status in English law, remain highly influential in New Zealand. There is only one real Australian challenger to those texts, and I'll come back to that one. Education also anchors New Zealand judges, particularly to the United Kingdom and away from Australia. All 56 judges on our senior courts were educated principally in New Zealand. Of those 56, 26 have foreign postgraduate degrees, 16 from the United Kingdom, half of those from Cambridge, 6 from the United States, 4 from Canada, none from Australia. Perhaps that partly confirms Ivor's sense of cultural affinity. For New Zealanders, and certainly for Australians, crossing the Tasman is not really an overseas experience. Other experience also leans away from Australia. None of the judicial biographies on the Courts of New Zealand website, and certainly my own knowledge of each of the judges, suggests that none of them have worked for any extended period of time in Australia. As far as we're aware, none were born there, whereas in contrast, a few Australian senior judges were born in New Zealand. In public law, we have each gone our own way, really quite dramatically. Michael Taggart, who is our most revered public lawyer, wrote, or was until he died, delivered a rather stinging lecture called Australian Exceptionalism and Judicial Review. It's not entirely clear what he meant. What is certainly true is that the public laws of New Zealand and Australia are very different, but we're exceptional on both sides. As he observed, Australia was then and remains exceptional in being the only English-speaking democracy without a judicially enforceable Bill of Rights at federal level. But he might also have said that New Zealand is relatively exceptional in being one of only 2 common law states not to have a written constitution. And the other, of course, is the United Kingdom, which has struggled with constitutional opacity in the wake of Brexit. There are Australian decisions at the highest level advocating caution and relying too readily on authorities from jurisdictions such as ours in the public law sphere. Whereas Bill Gummo put it in Momcilovic, Dycean notions of parliamentary sovereignty remain influential. That decision, with its constitution-driven exclusion of a strong remedial role for the Victorian Charter, stands in complete contrast to the approach we have taken under Section 6 of our New Zealand Bill of Rights Act. And in the construction of that statute, we have looked, if we have looked at all, for support to English decisions such as Gaidan and Kebeline. Momcilovic, we have simply put on one side and said that is an example of Australian exceptionalism, and that is exactly what the New Zealand Court of Appeal said 2 years ago. An Australian public lawyer looking at New Zealand would see much of the English tradition there in public law. Our common law constitutionalism has been described as a charming set of anachronistic contrasts. Peter Kane described your public law as a product of mixed parentage. On the one hand, British unitary constitutional monarchy, on the other, the American Federal Republic. Our public law is essentially the product of a single parentage. The real revolution in it came in the 1980s and 1990s under the influence of Sir Robin Cook, who sought simplicity based on broad concepts of legality, fairness and reasonableness. But then in 1996, 3 great events coincided. The first was that Sir Robin retired as President of the Court of Appeal. The second was that Sir Ivor Richardson, a more restrained public lawyer, assumed the presidency. But again, putting aside the big man theory, the most important thing that happened, the third thing that happened, was in 1996, we adopted mixed member proportional representation. And that was a direct response to 20 years of radical executive government under first the Muldoon National Government, which unexpectedly pivoted left, followed then by the David Lange Labour government, which unexpectedly pivoted right. The effect of that was to produce a groundswell for electoral reform, and the product of that was the adoption of proportional representation. That has been the most significant constitutional event in our history in the last 100 years. It is our version, I suppose, of federation in a way, because what it has done is to substantially strengthen the legislative branch of New Zealand government and to substantially deflate executive power. There's a great example I remember about this in the memoirs of the former head of the Prime Minister's Department. He was talking about a time that he was trying to advise Muldoon of how to or not to do something. And he said, "Prime Minister, you simply cannot do this. It's just not lawful." And Muldoon said, Mr. Hensley. He said, "Mr. Hensley." And he was on the 9th floor of the Beehive building, which is the executive building. He pointed down to the Parliament House, which is next door. And he said, We keep a little room down there to deal with problems like this. That was the state of our constitutional law until MMP took over. I opposed it at the time. I voted against it. I was wrong. It has been the most remarkable change in our constitutional history. One of the things it has done, though, is to completely deflate judicial review. And that's not because the judges are averse to review. It is because the executive is now averse to overreach. And that is the fundamental difference for us. Now, Kiwi exceptionalism. There are three things I just want to touch on, which also suggest that perhaps Bill Gummer was onto something in warning you about our public law. Because our public law is going down its own particular track, and that's for three main reasons. One is, of course, that we have our Bill of Rights Act, which is having a fundamental impact on public law. It is, in fact, the lively area in which, the lively part of public law now. As part of that, we have a court I presided over when I was in the Court of Appeal, Court of Five, inferred a right in the statute to issue what are called declarations of inconsistency, which is to say to Parliament, the primary legislation is not consistent with the Bill of Rights Act provision. Doesn't do anything else there, simply says they're inconsistent, doesn't strike it down, we have no such power, but it simply declares that difference. People have got terribly excited about this, and I think wrongly. We had a case recently which concerned voting age. The primary legislation, the Electoral Act, provides a right to vote at 18. The Bill of Rights Act has two different provisions which are themselves internally inconsistent. One echoes the electoral legislation by saying there's a right to vote at 18. There's another provision which says that you have the right to be free from discrimination, and discrimination in relation to age begins at 16. There's no doubt whatsoever that Parliament had no idea when it passed the discrimination amendment that it was causing this point of inconsistency. In the Supreme Court, we split 4-1 over whether a declaration of inconsistency should be granted. I was the dissentient in that instance, but it created great excitement. People announced that the Supreme Court had said that 16-year-olds could now vote. Well, we hadn't found in our box of tricks the power to overrule or invalidate the Electoral Act, so no, we hadn't. All we had said was that Parliament now had to consider the fact that it had passed two pieces of legislation which couldn't be read together. In fact, it had passed one piece of legislation which couldn't be read together, which was the Bill of Rights Act itself. And I think the excitement that has developed around this idea of a declaration of consistency will eventually deflate when people realise that it is really nothing more than a judicial advisory opinion to the legislative branch to say that is what your legislation means. It's a useful thing for Parliament to have an authoritative statement as to what its words mean. But what it does about the inconsistency, if there is one, is entirely for it. The other two things are connected with Maori. The Treaty of Waitangi, introduced in 1840, its shadow has darkened across the land over all the years I've practiced. So it would be a misguided judge now who did not think about the potential treaty obligations in construing statutory powers. It has reached that point of reference. Does it make great difference? In some cases it does. In most cases it doesn't, but it is something that will be considered, and it adds a difference to our public law that you will not, I think, find a reciprocal interest in. And the third thing is tikanga, which is the law of Maori, and that is the law that preceded common law being introduced into New Zealand in 1840. Now, Maori had their own law. Sometimes it was pan-tribal. In other instances, the laws were intra-tribal. And they were not displaced by the introduction of common law, and the treaty, if anything, preserves those laws. So they have come in to have an influence. They are custom, and custom is received by way of evidence, and can influence the form the common law takes. So quite recently there was an appeal brought by the descendants, or the estate I should say, of a man called Peter Ellis, who had been convicted of pedophile sexual offending in a kindergarten in Christchurch. It is fair to say there was grave public concern about the safety of those verdicts. And when eventually his case came up to the Supreme Court, there was a small problem. Peter Ellis had died. And the ordinary principle at home is that a criminal appeal abates on death, that there is a statutory power in a case where the interests of justice require it for an appeal to be allowed to continue. When the Supreme Court made its decision, I wasn't part of that panel, it was heard before I joined the court. When it considered that case, it said, what does tikanga say about reputation after death? Maori have a more profound sense of continuation of the spirit and reputation past death. And the court felt, and I agree with this, the court felt that it was right to take a more liberal approach to non-abatement in the event of death in criminal appeals, because that would have been consistent with the views of a significant stakeholder in our law, which is Maori. Just a couple of observations about private law. As regards equity, as I've mentioned, the influence of Australian analysis in the 1990s has been profound. But there have been vociferous complaints from Australia about grave doctrinal error in New Zealand. Famously, the preface to the 2002 edition of Gummo and Lehane's Equity, Doctrines and Remedies observes that in New Zealand the prospect of any principled development of equitable principles seems remote, short of a revolution on the Court of Appeal. The blame is largely, this consensus is Roddy Marr winding up, the blame is largely attributable to Lord Cook's misguided endeavours. That one man could in a few years cause such destruction exposes the fragility of contemporary legal systems and the need for vigilant exposure and the rooting out of error. Well, the New Zealand take on that very famous passage is that it involves a degree of Maorian overstatement. Ashburner's notion that the two streams of the jurisdiction run side by side without their waters mingling has never been our view about the place of equity and its relationship to common law. But although we have borrowed from other jurisdictions, some of those borrowings continue to meet with Australian disapproval. It is fair, I think, to say, and Keith Mason wrote a wonderful essay about this in his Lawyers Then and Now. The essay is called The Equity Wars, and I think that it relates to the difference taken by the New South Welsh equity lawyers over other Australian lawyers. We have, I confess, in New Zealand found an occasional temptation to go all Canadian. And so that has met with significant disapproval from Gummo and Lehane. For instance, we've accepted the idea that contributory negligence, or a concept of contributory negligence, can come into claims for compensation for breach of fiduciary duty. We have allowed exemplary damages for breach of an equitable duty of confidence. And very recently, in a decision that I was part of, we have followed Canadian authority and we've rejected Australian authority, a decision here called Paramasavam. We have followed Canadian authority and held that a breach of fiduciary duty can be found in the case of a father who physically and sexually abused his daughter during her minority. The court then split on the remedy, and two of us held that the only remedy available here was not proprietary but equitable compensation, so damages. And that case is now going to the Supreme Court in June, where alas I will not be sitting on it. Mm-hmm. Contract. One of the surprises of our study was how little the High Court of Australia decision in Cadelpha had been cited in New Zealand. It was certainly cited to the courts a lot. In fact, I loved Cadelpha, and my principal area of practice in the 1990s was contract law. contract cases, and I thought the sun shone out of Cadelpha. It was, and I must say, so did most of my brethren and sisters at the commercial bar. It was, of course, relatively parallel to the House of Lords decision in Brennan Simmons, and it held up something of a bar to the barrage of super contextual extrinsic evidence that has, since the misguided speech of Lord Hoffman in Investors' Compensation, broken through, which I think has come at a huge cost to litigants, and it has rather put the equitable doctrine of rectification into a rest home. But that battle has been lost in New Zealand. My judgment in a case called Bathurst, in which I attracted the support of two very fine other contract judges, Justice Gilbert and Justice Goddard, fell over 5-0 in the Supreme Court, although they did split on the facts. Your Australian decisions on the doctrine of penalty have been very influential in New Zealand. Pacheco, for instance, has been followed, but we still follow England in confining the doctrine of penalties to remedies for breach. Tort has been is an area of real interest. We have borrowed much from you in the area of defamation, and that certainly Australian cases have been influential there. Slightly less so in negligence. Our law has been reforged in the context of two public catastrophes. The first was the leaky homes syndrome, which I mentioned before. The other was the destruction of large parts of our kiwi fruit industry by the PSA3 bacterium as a result of the carelessness of the Ministry of Agriculture in granting import permits for pollen, kiwi fruit pollen from China, without a proper post-entry quarantine assessment. We have, in New Zealand, continued to apply, and our law of negligence remains grounded in Anne's of the London Borough of Merton, which articulates a two-stage test for finding a duty of care in novel categories. You in England have long said goodbye to Anne's, but one consequence of that is that New Zealand has been has favoured more remedies for economic loss than you have here. So that's a gallop. I think probably Jim Merrills would have appreciated the gallop, because that was part of his interest as well. But I'm just going to offer a few very brief expectations. Punditry is always perilous, but Professor Cheryl Saunders' assessment that the degree of divergence between New Zealand and Australian law, and she was talking about public law obviously, but I think her assessment appears sound on the evidence. It probably means that in the field of public law, New Zealand and Australia will say less and less to each other, and that's a pity. Public law citations across the Tasman in each direction are unlikely to expand proportionately, but in private law there remains room for greater cross-citation. Claims of equitable apostasy in New Zealand are overstated, and greater convergence there may yet occur as greater orthodoxy reasserts itself, apart from an occasional Canadian-style departure. In tort, we continue to find common cause in defamation and, to a slightly lesser extent, in negligence. In contract, the question remains whether Australia maintains divergence by retaining Cadelpha's ambiguity threshold for receipt of super contextual extrinsic evidence. But then sometimes a little divergence is not necessarily a bad thing. Onorera, tēnā koutou, kia ora tātou katoa.
Thank you very much indeed, Justice Kós. It was absolutely fantastic. Better the second time, can I say? Now, I'm not sure what time it is, and whether we have.
We've got 5 minutes for.
Let's take 5 minutes for one or two questions, and if you just raise your hand, I'll bring the microphone to you, and you can fire your questions away. Yes, so I'll just. I gather we're recording this, and that's the.
Thank you so much. Judge, my question is on trusts law. From my personal experience, I can say I find Kiwi trust decisions, particularly over, say, the last 10 years, quite useful, and I'd also observe that Lewin on trusts, the authors or the learned editors, as I refer to them, so I was always quite keen to find Kiwi decisions referred to them as, indeed Channel Islands decisions and Australian decisions for that matter as well. I know you touched on equity, but you didn't address trusts. Do you think my observation is merely personal, or do you think there's some empirical basis perhaps for that?
Well, I'm pleased you find New Zealand decisions helpful in the trust field. I've written a lot of them because it's a field I like very much, and it is certainly true that we make a lot of use of Lewin, or I do. We have a new Trusts Act,
Yes.
and that potentially creates room for divergence, but the Trust Act is primarily a framework for decision making. I don't think it fundamentally alters the basic obligations of a trustee or the basic rights of a beneficiary. So we will, I think, continue to use English law. We have not, as I think, turned as much to Australian law, and so if I go back to New Zealand with one good benefit from this lecture series, maybe your question, sir, because it probably prompts me to open up. Is it Ford? What are the great texts?
Jacobs, I suppose.
Jacobs, yes, that's right. Yeah. So I think those texts are underused, and we should go back and look at those again. So thank you.
One more question?
You referred earlier to the rise of statutes, and I wonder if you were looking across the New Zealand reports over time, since 1950, whether you just see a greater proportion of cases that are interpreting local statutes with a diminution in consideration of what once would have been our common law, but generally the common law of New Zealand, or correspondingly there mightn't be as much attention to the common law of Australia because most of our work is, or an increasing amount of our work is interpreting statutes. So looking over your own law report, so to speak, how much of it is concerned with the interpretation of statutes? Is that a driver as to why we're not citing English authority?
Absolutely no doubt that that's right. That's certainly an important factor. We had, particularly when the legislature was dominated by the executive, an over-energetic legislature, because the government would have a notion to pass an act and could pass the act. This caused Sir Geoffrey Palmer, who became Prime Minister at a time still under first past the post, where I don't think he necessarily followed his own advice in debating the progress of legislation, because he was head of a Labour government, and Labour governments usually have quite a lot of legislation to pass. What would be interesting to know, and you've prompted me to go back and find out, is whether the rate of production of legislation has gone down since the introduction of proportional representation, because legislation now requires deals to be done. We have had only one administration that has had outright power since proportional representation was introduced, and even that administration chose to take in a coalition partner. So there's no question, you're right, that is certainly influential in both countries.
Well, we might leave it there. Justice Kós, thank you very much indeed. Now, I gather that the work that you've presented this evening is to be published in the New Zealand Law Journal? Law Review, sorry. So those who would like to take a look at that journal when the issue in question is published will find everything laid out there. So it just remains for me to thank you all for coming, to thank Damien and the Bar Association for your generous hospitality. It's greatly appreciated. And of course, Justice Stephen Kós for a brilliant lecture.